Hi everyone, in this video we're going to quickly run through Bowen Investments and Tabcorp. Okay, share screen. Okay, ready. All right. So this case deals with property damage and the proper measure of damages in a property damage case, which is a breach of contract case. Okay. All right. So in this case, Bowen Investments was the landlord of an office building in Melbourne. Okay. And in this case, the two landlords, the couple who ran Bowen Investments, they really liked making nice buildings. Okay. So in this instance, Tabcorp was their tenant and they jackhammered the stone flooring in the foyer of this building. And this flooring, if you can have a look at the facts on the slide here, this flooring had Canberra York grey granite. Okay, so very fancy, very special granite. And when Tabcorp jackhammered the stone flooring, they did so in breach of contract. There was a covenant in the rental agreement where Tabcorp agreed not to make substantial alteration to the premises. What else do I have here? So Tabcorp hadn't received written consent to destroy the flooring in the foyer. And when the landlord found out, Tabcorp continued to alter the foyer and replace it with a new foyer despite protests to the contrary. Okay, so one of the key issues in this case became what was the appropriate method of calculating the damages. The two options were the reinstatement costs, that is the repair costs, so the cost of returning the foyer to its original condition, which was a cost of approximately $1.3 million. And the alternate way of potentially calculating the measure of damages here was the diminution in value method. So essentially, what is the difference in value between the old foyer and the new foyer, which was only $38,000. So you can imagine here, Tabcorp, had a vested interest in the diminution in value method, whereas on the other hand, Bowen Investments would have wanted that reinstatement cost method, okay, the repair costs, okay, the 1.3 million. Okay, so at first instance, the trial judge actually found damages of $34,000 here. So the difference between the old foyer and the new foyer. Okay. However, the federal court then found in favor of the alternate method of assessing damages, so those repair costs, and increased the damages award to $1.28 million, which was the cost of restoring the foyer to the original condition, plus lost rent for when the restoration was taking place. Okay, and then the High Court then affirmed that full federal court decision. So they dismissed Tabcorp's appeal and said that no, the diminution value method wasn't appropriate here. This was definitely a repair cost case. This was a reinstatement cost case. And the reason why they saw it as appropriate here was they held that Tabcorp hadn't discharged the onus of showing that reinstatement costs was a reasonable or necessary course of action. So Tabcorp had actually argued that the plaintiff, Bowen Investments, hadn't, shown that it was reasonable or necessary. So they had argued that Bowen Investments actually held the onus of showing that reinstatement cost was reasonable and necessary. And the court said here, no, it was up to Tabcorp to displace that, and they hadn't done so. Okay, so there was no argument around the test that actually applied, which was whether reinstatement cost is reasonable and necessary. It was just around who bore the onus for showing or displacing that test. Okay, that burden. Okay, all right. So we'll go through the case reading guide now. All right, so here, the first question that I had was, what was it going to cost to restore the foyer of the building to its original character, its original granite? Okay, here, $1.38 million. Okay. The next question, so how had Tabcorp's alterations to the foyer affected the value of the building? Affected it very minimally, okay, only around 34,000 according to the trial judge, but essentially there was negligible diminution in value. Okay. The court in this case based its decision on the rule in Joyner and Weeks, and you can see in the slide that rule here. But Finkelstein, we're not supposed to have an addition of your pop. Just when you thought that COVID videos weren't going to be happening, here they are. Sorry, getting back to it. But Finkelstein and Gordon also refer to the basis of for assessing compensation in cases of damage caused to property and breach of contract, where two bases of assessment do they cite? What two bases of assessment do they cite, and how is one chosen over the other? Okay, so they're those two methods that I mentioned earlier. So diminution in value and reinstatement costs / which means repair costs essentially. Okay, so they're the two ones that are mentioned in the reasoning. And the court states that the correct measure is what is reasonable for the wronged party to recover, and an assessment of what is reasonable is not measured in purely economic terms. So the fact here that the landlords, you know, loved constructing beautiful buildings, and that wasn't just about, you know, purely an economic thing. They weren't necessarily doing it just to increase the value of the building, but just because they purely loved that aesthetic. That was able to be taken into account here when assessing reasonableness. So it's not necessarily reasonableness from the perspective of an economic, rational actor, you know what I mean? Like reasonableness is just not just about financial considerations. That's what I'm trying to say. Cool. Okay, and then going over the page, oh yeah, and then the crucial thing here in our case, in terms of how is one to be chosen over the other, it came down to whether the reinstatement cost was reasonable and necessary. That was found to be an onus that the defendant had to displace, and they hadn't done here. Okay, so it's not just about the test, it's about who has to show, okay, that the standard is reasonable or unreasonable in the instance of Tabcorp. The next question, so if the plaintiff contracted a painter to paint her house a specific colour and the painter applied a different colour, is the plaintiff entitled to recover the cost of repainting? The answer here is yes. So this reinstatement cost is reasonable and seen as reasonable and necessary in the circumstance. You can see that at paragraph 93. In terms of the second part of the question, does it matter if the person didn't intend to have the house repainted? This is interesting because it goes to that question of potential overcompensation. Because remember, compensation principle would put you in a position as if the contract had been performed. And then if you don't then use the money to repair, it's a question of whether that amounts to overcompensation. But here the court says, no, it doesn't matter if you don't intend to have the house repainted. The reinstatement cost best meets that compensation principle. And then in terms of why or why not, so where reinstatement is reasonable, the owner who chooses to make do with the defective contractual performance is still entitled to the appropriate measure of damages, because that is the measure of what they have lost, okay? And then the onus of proof is on the defaulting party to establish that reinstatement cost was not a reasonable, necessary, or realistic course of action, okay? In this case, to be adopted by Bowen Investments, and Tabcorp couldn't show that. So yes, that is Bowen Investments and Tabcorp.